We represent Mike Lindell. You may have been aware of that. He's the pillow guy. And we represented him well before his lawsuits with Dominion voting systems. He's trying to protect us all from inaccurate vote counts by tabulation machines that can be manipulated without people even knowing. It can be hacked and manipulated. And so the voting machine companies sued him for defamation because he said, that their machines are Swiss cheese and you can get in and hack computers and we shouldn't be using them. There were 3 significant cases brought against MyPillow and Mike Lindell. One in Washington, D.C. by Dominion Voting Systems, another in Minnesota by Smartmatic Corporation, and another by an individual accusing Lindell and MyPillow of defamation in Colorado. And in our handling of those significant billion-dollar lawsuits, we not only became much more familiar with the election system that we use here in this country, in most states, if not all, but the ways in which they can be manipulated or hacked and what the security is that's being used to prevent that, and all of those issues to determine whether what Mike Lindell was saying, he had a good faith basis to say, whether they end up being true or not. And so it's the interface between the First Amendment and defamation law. And the First Amendment allows us to say whatever, whenever we want, and particularly when challenging the government, which in these cases, we argued these voting system companies were effectively the government because they were counting our votes. You can't just outsource the counting of votes and claim you're not the government. Government's quintessential responsibility is to count in a democracy and to determine winners based on a vote count. So when we were handling these cases, and you have the total ability to challenge the government and to speak out against the government, we looked at the interface with defamation law because there is an exception in the First Amendment. You can say whatever you want, but you cannot say things, particularly regarding public figures, with actual malice, which means reckless disregard of the truth. It's not just a false statement, because even if it's false, you can say it, but if you did know it was false, you can't. Or if you should have known that it was false. That's the cutting edge between where the First Amendment runs and where it ends, and defamation begins. And the U.S. Supreme Court is now starting to look at those cases to draw that line and to determine where that line is. And our firm is at the cutting edge of that. And so we do a lot of First Amendment work and defamation work.